Welcome to The Explainer. Today, we're diving into a really high-stakes legal drama that went all the way up to the Constitutional Court of South Africa. We're looking at the historic appeal of Allan Aubrey Boesak. Now, this isn't just a story about a famous figure facing criminal charges. We're actually going to use this fascinating case as a vehicle to explain these super strict, unyielding boundaries of a constitutional court. Like, when does a disagreement over facts escalate into a full-blown constitutional crisis? And when does the highest court in the land just look at a case and say, nope, our doors are closed? Okay, let's dive into this. First up, we'll look at the leader and the funds. Then we'll hit the ultimate legal threshold, followed by the right to silence. After that, we'll weigh facts versus presumed innocence, and finally, we'll wrap up with the final verdict. So, Section 1. The leader and the funds. To put this whole puzzle together, we really need some context. Allan Boesak was a prominent anti-apartheid leader, and his congregation set up a foundation to help victims. Because of his massive profile, donations just poured in from all over the world, including this absolutely staggering figure, over 682,000 rand. I mean, to put that into perspective, that would easily translate to millions in today's money. This specific chunk of change was donated by an American entertainer for a newly formed children's trust meant for child victims of apartheid. But the state alleged Boesak only transferred a fraction of that money to the trust, fraudulently misrepresenting the total donation and basically keeping the balance. Now, Boesak's defense? He claimed the donor actually intended for him to keep that balance for his own personal use. This exact dispute became the foundation of counts 4 and 5, which ultimately led to a conviction for fraud and theft. Let's trace his legal journey here, because it's quite a ride. In March 1999, Boesak was convicted in the High Court. Fast forward a bit to mid-2000, and he took his case to the Supreme Court of Appeal, or the SCA. The FCA dropped one count, sure, but they upheld his convictions for fraud and theft on counts 4, 5, and a portion of count 31. That landed him a 3-year prison sentence. Unwilling to just accept this, Boesak made one final massive push, attempting to use the Constitution itself as a shield. By December 2000, he was seeking special leave to appeal right to the Constitutional Court. And that brings us to Section 2, the ultimate legal threshold. And this brilliantly illustrates how South Africa's legal system is structured. You see, the Constitutional Court isn't just the next rung on the ladder. You basically need a highly exclusive VIP pass to get in there. Take a look at this. On the left, we've got the Supreme Court of Appeal. This is the absolute highest court of appeal in the land for everyday criminal and civil matters. But over on the right, the Constitutional Court. By law, it can only decide constitutional matters and issues directly connected to them. There has to be a strict boundary here, right? Because if there wasn't, literally every single criminal case would just keep appealing all the way up to the Constitutional Court, and the SCA's authority wouldn't mean anything at all. So what exactly gets you that VIP pass? Well, it comes down to a really strict definition. A constitutional matter is a dispute over whether a law or someone's conduct violates the Constitution or the Bill of Rights. As Deputy President Langa pointed out in the judgment, just disagreeing with how a lower court weighed the facts, yeah, that's not going to grant you access. You literally have to prove that your fundamental rights were breached by how the court applied the law. Which perfectly sets up Section 3, the right to silence. Boesak actually argued that his right to remain silent, which is protected under Section 35 of the Bill of Rights, was violated. And that brings up a super interesting question for us. Does a failure to testify equal guilt? Let me set the scene. During the trial, the state produced a letter on foundation letterhead. It appeared to have Boesak's signature on it, and it acknowledged the donated money. Boesak chose to exercise his right to remain silent, meaning he didn't testify to explain or dispute this letter. Later on, he claimed that because the state didn't bring in a handwriting expert or a direct eyewitness to prove he actually signed it, using that letter against him violated his right to silence. Now, what's really interesting about this slide is how the court broke down the circumstantial evidence. They showed that having a direct eyewitness isn't the only way to prove a document is real. The court asks some very specific questions. Did he authorize the letter? Did he instruct its typing? Did he have knowledge of its contents? Did he affirm it by signing? Based on all this, the court found a strong prima facie case. That basically means, at first glance, the evidence strongly pointed to him as the author. And here is the kicker. During the actual trial, his defense lawyers never once suggested the letter was a forgery during cross-examination. Not even once. So this builds directly into the court's really firm stance on the right to silence. The Constitutional Court drew a hard line here. You absolutely have the right to remain silent, for sure. But that right has consequences. South Africa operates on an adversarial legal system. If the prosecution brings forward strong, unrefuted circumstantial evidence, that prima facie case we just talked about, and you choose to stay completely silent instead of offering an alternative explanation or claiming forgery, well, you're taking a huge risk. The court is totally legally permitted to weigh that unrefuted evidence and say, yeah, this proves guilt. Weighing evidence is just not the same thing as forcing you to speak. I absolutely love this quote from the judgment because it just nails the court's frustration. A criminal trial is not a game of catch-as-catch-can, nor should it be turned into a forensic ambush. Think about that. Basically, they're saying you can't just sit silently through a trial, not bother cross-examining anyone on a document's authenticity, offer zero defense of forgery, and then try to ambush the appeals court later by claiming, hey, that document was never properly proven, my rights were violated. The Constitutional Court essentially said no way. The SCA assessing unchallenged evidence, that's a factual matter. It is definitely not a constitutional breach. Moving right along to Section 4, Facts versus Presumed Innocence. This particular conflict stems from Count 31. This is where Boesak was convicted of stealing over 147,000 rand, which he claimed was just him paying himself back for a loan he'd previously made to the foundation. He argued the lower court totally misinterpreted the facts, and by doing so, they violated his presumption of innocence. But here's where we have to draw a stark line. On the left, you have a factual disagreement. That's when you argue the court looked at the evidence and just came to the wrong conclusion. On the right, a constitutional breach. This happens when the court applies the wrong legal standard entirely. The Constitutional Court noted that the lower courts applied the standard of proof beyond a reasonable doubt perfectly. Boesak wasn't saying they used the wrong standard, he was just saying they got the facts wrong. And, as we're seeing, dressing up a factual dispute in constitutional clothing, that does not get you the VIP pass. So, Boesak makes one final push. He basically argued that because the court got the facts wrong, sending him to prison meant he was being deprived of his freedom without just cause, which would be a direct violation of Section 12 of the Constitution. The court dismantled this pretty quickly. They clearly defined just cause. They said, look, if you're giving a constitutionally fair trial and you are convicted of a serious crime like theft, that conviction all by itself is a legally acceptable reason, a just cause to imprison you. And that brings us to our final section, the final verdict. The Constitutional Court meticulously stripped away all these constitutional arguments to see what was really underneath. And so, Deputy President Langa, delivering the unanimous judgment of the entire court, handed down this incredibly definitive resolution. The application for leave to appeal is refused. The court stood their ground. Because the issues Boesak raised were, at the end of the day, purely factual disagreements cleverly disguised as constitutional breaches, the Constitutional Court refused to just be another court of appeal. The Supreme Court of Appeal's decision was final. The end. I want to leave you with this final thought to ponder, based on everything we unpacked today. If the facts of your case are against you, can the Constitution ever truly save you? This case is such a powerful reminder that while the Constitution is this incredible, vital shield for our fundamental rights, it's not a magic wand. It can't just erase circumstantial evidence or rewrite the factual record of a fair trial. Thank you so much for joining me for this explainer, and keep questioning the boundaries of the world around you.